Hi, attorney Jason T. Brown, the head of Brown LLC, a whistleblower law firm. One of the most common questions we receive is, how do you become a whistleblower? Well, in order to qualify as a whistleblower, you need to have information generally from the inside that cognizably fits inside a certain statute. So just because you have information that a company is behaving poorly or unethically or even unscrupulously by itself, even though intuitively you may think that, hey, I want to blow the whistle on the fact, like, say, for example, a company may be using the wrong recycle bags. Well, unless there's a statute that specifically envisions how you hold a company accountable for that, you can't really blow the whistle or do a whistleblowing activities as contemplated under the law. Certain states may protect you as an employee to report conduct that's incompatible with an existing law, but the big statutes to blow the whistle under the last few decades are a few, starting with something called the False Claims Act. The False Claims Act is a statute in which you can blow the whistle when there's a systemic fraud against the government. The big areas in which people blow the whistle and the cases that have produced the most profound results have to do with Medicare and Medicaid fraud. When there's systemic fraud against either of those government programs and therefore fraud against the taxpayer, for things like upcoding, for things like phantom billing, for things that can involve evading 14-day rule. In the pharmaceutical sense, if there is a pharmaceutical product that had falsified its NDA, a new drug application, and the government paid for a whole lot of that product, that can constitute Medicare, Medicaid fraud if Medicare, either of those programs paid for that. Well, if you blow the whistle under the False Claims Act, also the other big space, of course, defense contractor fraud. When a defense contractor defrauds the government out of money through sneaky things they may do through the contract, and there's lots of industrious ideas that they sometimes employ in order to maximize the recovery for the company and then hurt the taxpayers in turn. Well, the False Claims Act allows whistleblowers to come forward and blow the whistle and in turn receive up to 30% of what the government recovers if the case is successful. And that's been a huge statute over the years, averaging several billion a year, averaging a couple $100 million for whistleblowers each year. I don't want to throw huge money and numbers at you to think that, hey, I have a case, so therefore I'm getting $100 million. That's just not the case. On average, there's something called an intervention versus non-intervention track. The intervene cases, that's when the government in the False Claims Act decides to take the case. Those wind up resolving on average around 13 million. When the government doesn't, it's around 3 million, but you'd be entitled to a larger percentage. But also throwing that equation to balance it out is a couple other factors, and we can get into in another video, which is there's more cases that fail than succeed, no matter how earnestly you believe what you know and think is actionable. So moving on from the False Claims Act, other types of whistleblowers that have been successful over the years are the SEC whistleblowers. The SEC has to do with when a regulated entity under the Dodd-Frank or other program that generally engages in securities commits pretty much an act in which it puts its own interests before the best fiduciary interests of the clients and our customers. There could be all sorts of violations. Inside trading's a big one. Of course, Ponzi schemes, a huge one. Also, another facet of the SEC is they want to make sure that companies that are regulated by its province keep a strong audit trail. And the failure to keep an audit trail or burning an audit trail may be a separate offense. And there's been hundreds of millions of dollars over the years that have gone to SEC whistleblowers. Particularly that type of violation generally are insiders that are well placed, that know really the schematics of the scheme that's employed. Other whistleblower programs, the IRS whistleblower program, that's if somebody evades substantial taxes of $2 million or more of liability. Those cases have to be teed up pretty concretely for the IRS to take action. In the last couple of years, there's been enhancements to the anti-money laundering whistleblower statute. We haven't really seen a big result under that yet, but I'm pretty confident that based upon the activity with that program, there is going to be some huge results that are upcoming. One big thing about money laundering is really concealing the origin of funds and utilizing United States banks. And with a list of prohibited countries, like for example, Russia right now, if funds originate and are secreted from Russia using US banks, I think the money laundering division will be taking some steps, and whistleblowers can get a big percentage of whatever is recovered through that program as well. NHTSA, something that implicates the safety of the highways and the roads. That statute gets even more defined about who can qualify as a whistleblower under it. And certain states have their own whistleblower mechanisms. Surprisingly, states like California and Illinois, actually comparable to the False Claims Act, allow whistleblowers to bring actions that enforce rights for insurance company if insurance companies are defrauded systemically. So that's another avenue to investigate. And certain states like New York, and I believe Connecticut just passed one, if there is a tax fraud, under New York laws have been successful over the last decade where they're evading New York state taxes, then you could bring an action under that to try to recover the money for the taxpayers of the state of New York, and also in turn receive a portion of the recovery if the case is successful. So basically, you have information, you want to be a whistleblower, you don't know who to turn to. I can tell you one thing you shouldn't do. Generally, one of the honeypot or traps is to internally report it through a company's compliance mechanisms. As much as the company pretends that they want you to report it, they don't. When that happens, they're going to look to blame anyone and everyone, and oftentimes you as the person who reported it will be put into a very compromising position, and then you're going to be coming to an attorney scrambling in a defensive posture as they try to do something to discredit you versus a advance the ball type of position in which you bring it to the attention to the right authority first. Another thing that you should consider is a so-so route is to bringing it directly to the government. The government is here to help you. Well, we know that's just not the case. And it's like nerd speak, you need to speak nerdum. You need to have a law firm that interfaces with the government in the ways that they speak to make sure that you're not in any trouble when you bring it to the attention of the government. Further, if you directly bring it to the attention of the government without invoking the right mechanisms, you may go through all the heartache and hardship without any of the upside, because you need to technically file things the right way in order to invoke, let's say, the benefits of something like the False Claims Act, in order to obtain an SEC whistleblower award. So with all these different avenues for potential recovery and a couple potential pitfalls, the one strongest advice I can give is if you have information where you think you want to blow the whistle, why not enjoy the opportunity to speak to a whistleblower law firm that focuses his practice on protecting whistleblowers? So number one, you know if it's actionable or if they think it's actionable. And number two, the real question to ask that particular firm while you're vetting them is, have they handled something comparable to your situation in the past? Do you think the potential avenues and routes to recovery are versus the potential hardship about bringing the action? And if they're experienced and seasoned in the field, like I like to think we are, Brown LLC, our site, ifightforyourrights.com, but if they are, hopefully they'll give you some good sound advice that you can help and to utilize to determine what route it is that you want to take with your information.